Dear viewers, welcome to this episode of Expert Speaks. People think their job is done once the will is written. Many people do not know it is very essential that you draft the will correctly, keep it simple, put all the details. If you forget to do any of these things, or if you leave the loopholes, instead of will solving the problem, will itself can become a problem. In this episode, I'm going to talk to expert of the week, lawyer Aditi Joshi, about the complications which may set in the event of improper drafting of this will. This is NRI Money Clinic for you, and I am Dr. Chandrakant, but your financial guide for a happy living.
NRI Money Clinic. No hype, just the right advice.
Dear viewers, to talk to you about how you should draft your will, what complications might set in case if you improperly draft the wills, I am invited for this episode, expert of the week, lawyer Aditi Joshi. Aditi Joshi is a person with 14 plus years of experience as a lawyer specializing in wills, inheritance, and commercial law. She comes with a rich experience of working in multiple places. She has worked earlier with Kotak Mahindra Trusteeship. She has worked with the MFUG Bank, earlier known as Bank of Tokyo, and Paras at Kuhad and Associate Advocates. Her areas of specialty include consulting on will creation and structuring of trust. Welcome to this episode, Aditi Joshi.
Thank you so much, sir. It's always such an honor to come and be on your platform and discuss such important topics. Thank you once again.
My NRI community is always full of ears when people talk about wills, inheritance, because they are concerned about the assets that they have back in home. You have spoken on the channel multiple number of times in the past, and you have given clear instructions on how it has to be done, drafting and other things. Today we move to the next stage. There are people who do the wills, write wills. What complications might set in just in case of the wills being poorly drafted, not clearly explained, not having enough details? For the benefit of my audience, the question that I have is, what happens when the wills are drafted not in a correct way? Can you please briefly? I would also request you to give me a couple of case studies on how people have failed in spite of having a will.
Thank you, sir. That's actually a very, very relevant question that you asked. So, before even we get into the factors regarding challenging a will, to give our audience some better context, I'll quickly touch upon what a will is and how it can be made. So obviously our audience can correlate what are the challenges. See, basically, a will is a simple legal document in which an individual can specify how they want their assets to be divided amongst their family members or beneficiaries. This document can also specify other things such as funeral arrangements or, guardianship of minor children. However, it is most important that all the wishes are clearly specified. Now, some basic legal requirements are to be met with in order for a will to be considered as properly executed in India. For example, the testator, that is the person who's creating the will, should be of sound mind. He has to be 18 years of age minimum. The person who's making the will needs to hand sign the will, that is, digital signatures are not permitted in India. And lastly, 2 witnesses are also needed to sign this particular document. So like I said, these bare minimum parameters are needed in order for us to create a legally valid will in India. Now, although it is really simple to create a will as it may sound, the same can be challenged on a variety of grounds. When we say challenged, it means when a will is drawn, somebody can go to the court and say, look, this will has XYZ issues, and that is why I request the court to consider that this will is not valid. Let's take a look at some of these grounds. Firstly is fraud. What this means is that suppose somebody tricks another person into signing a will by misrepresenting its contents. To give you an example, let's say, somebody tells an elderly person, okay, this is just a medical form, signed it, but actually it's a will. This is fraud. Or let's say, if an elderly person understands only regional language, but if the will is drafted in English, and the person is misleading this elderly person regarding its contents, this is also fraud. There's another factor which can lead to a will being contested is undue influence. What this means is that sometimes a person may be in a certain position to influence another person, basically to put certain pressure or exert coercion on the other person, which leads them, which rather, makes them feel threatened that they have to change their decisions. This, I can give you another example is, let's say if a elderly NRI has a caretaker. Now that caretaker can isolate that person, put pressure into modifying the will in their favor. This is known as undue influence. There's also another important and a simple factor is that, like I said, the person needs to be of sound mind. This simply means that when somebody is of sound mind, they are in a position of understanding what their actions are and, of course, consequences of those actions. So when a person is not of sound mind, they can't really create a will. Example, if a person is suffering from severe dementia, then in that case, they're not able to fully comprehend the nature and extent of their actions. And this can lead to, obviously, questions being raised regarding whether this will was properly created or not. And lastly, if the will is not properly executed, then also it can be challenged. I'll explain this to you by giving some facts. In Dubai, if a non-Muslim is creating a will, as a part of the formalities in order to create a legally valid will in Dubai, people need to go to the DIFC, that is the Dubai International Financial Center, and register their will over there. So this is a part of a formality. Now, if this is not done, in that case, it can mean that the will is not properly executed and can be held as invalid. So similarly in India, like I mentioned, you need 2 witnesses for it to be considered as a, properly executed will. So if a will is created without having these 2 witnesses, then also somebody can contest that, look, this will was not properly created. So these are several important factors that one needs to bear in mind. And of course, for the viewers of your esteemed channel, in the end, we'll also share some tips on how you can plan to increase the robustness of the will.
Aditi, thank you very much for highlighting the points on which the wills can be challenged. You also mentioned that the will should clearly express the wishes. It looks quite abstract for me. Is it possible for you to explain this with the help of a case study, how the wishes have to be explained in clear terms?
Sure, sir. And you asked actually a very relevant question. See, while having a will in place is very important, and like you said, even more important is to make sure that the will is clear and unambiguous. The consequence is that if, you leave behind a will which is not clearly drafted, it can actually leave your family clueless and confused, and that can cause even more harm than good. So, I'll share the case study as you requested. Some time back, we were advising a family. There were 2 brothers. One was a resident Indian and the other brother was an NRI. They purchased a plot of land together in Delhi. You know how it used to be in olden days, right? Trust amongst siblings was solid and word of mouth had huge weightage. So although both the brothers contributed to that purchase, the property was in the name of the resident Indian brother. This was again very common in the olden days, like 2 people are contributing, but the property was held in the name of one person. Now on this plot of land, they constructed 2 floors, and there was also a third floor having a terrace, and a comparatively smaller structure was constructed on that terrace. they also had a huge garden on that property. Both the brothers had a good understanding between them while they were alive. So that time there was no problem. Now, the NRI brother passed away first. So after the NRI brother passed away, the resident Indian brother, he wrote a will. In that will, he said, ground floor of the house will belong to his own children. And regarding the first floor, that will be passed on to his brother's children. Unfortunately, in this will, he forgot to mention the third structure on the terrace and the garden. Now, this is a classic case of the will not clearly listing down the details of the assets. Another important part that this will missed out was adding a residuary asset clause. What this means is that, yes, sometimes in a will we mention A will go to this one, property B will go to this one. But we need to have a clause which will say any other asset which I have not specifically mentioned here, that pool of residuary assets will be passed on to so-and-so. Now, because this will did not have such a clause, there was no mention about a garden and that particular structure. So naturally, there was a dispute after the resident Indian brother passed away, because both the branches now started contesting regarding the ownership of this third structure in the garden. The resident Indian brother's family said that, look, the property was in our father's name, so it belongs to us. Whereas the NRI branch contended that they had a share too, because their father had made monetary contribution regarding the purchase. Of course, a suit was filed, matter went to court. We helped them eventually settle the matter. But such disputes arise because the will did not clearly list down the assets. There's also a very interesting Bombay High Court case that I'd like to point out, which will add on to this aspect of how words in a will can make such a huge difference. So this was a case of Freddie Bisney versus Rusby Mistry. Now, Freddie, that is the person who filed the case, she had a cousin. Now, the cousin actually was unmarried and she passed away. This cousin made a will, left a will behind, but it was quite ambiguous. So in the will, the cousin mentioned that flat, garage, furniture, fixtures, household, and all other things in it, this phrase is important, and all other things in it will go to the cousin Freddie. So essentially, a large share of assets were bequeathed to Freddie. In this will, there was a residuary asset clause, which means that whatever assets that the cousin had not clearly listed down, they went to a separate pool of cousins and beneficiaries, and even charitable institutions were included. Now comes the twist in this case. Interestingly, certain physical copies of the shares worth, crores of rupees were found in that flat at the time of her demise. The will did not specifically talk about these shares. So the question now arose, when the will said all other things in the said flat, will that include the shares which were newly found or not? So naturally, if the court held that the phrase all other things in it included these shares, then it would go to Freddie. And if not, that it will become a part of that remaining residuary pool of assets and it will go to the other pool of beneficiaries. So there was a dispute between them. And in this case, the Bombay High Court finally opined that the intention of the cousin, that is the testator, was when she said all other things in the said flat meant only household articles, when she said furnitures, fixtures, vessels, paintings, and it did not include the shares. Now, this exactly shows how important it is to clearly draft a will so that all these interpretations later are not left to the court.
Aditi, that's really interesting. That's really, really interesting. That takes to the point. What is that exactly that needs to be captured? What kind of details have to go into? What makes it picture perfect, crystal clear, no room for any ambiguity, no need of a court to decide on what exactly is meant by the will. Can you help my audience understand this?
So essentially, when we speak about clearly stating details, what this really means is that the assets are clearly and very simply mentioned and identifiers are captured. Of course, the more details, the better, but at least basic information is needed. Example, in case of bank accounts, the bank, bank name, branch, bank account number, they're important. In case of real estate, identifying the flat, the plot number, area, pin code, all these are important. In India today, 1,50,000 crores of assets are lying unclaimed. This means nobody has come forth to claim those assets. The reason being is that families are not aware of the existence of these assets at all. You saw in the Freddie case, because there were physical share certificates, they found it. Today, everything is being digitized, so there is no way to trace anything if the owner does not come forth and tell that, look, this is what I own. And hence, we as family, we're working so hard to build assets for our loved ones. It's our duty that we inform our families about our assets and we don't add on to this corpus of unclaimed assets anymore. So let me share one more situation that we recently encountered. Now, this was a situation of resident Indian parents. Their children were both NRIs studying abroad. These were COVID times, unfortunately. Father wrote a very basic will. He simply mentioned, all my assets will go to my wife. He did not consider even the next in line of beneficiaries, which means in case if my wife were to pass away, to whom these assets will go to. He did not even mention, any details about the assets, because no bank account, no mutual fund related details, no fixed deposits related details, nothing. Unfortunately, like I said, these were COVID times. The mother also passed away shortly. Now, this meant that because there was no secondary beneficiaries, that is next in line, it was as good as the parents passing away without writing a will. Now, the children really struggle to locate what the assets are. I'd like to ask the viewers a question. How many of us really do know what is the bank account that our parents are operating, or what is the fixed deposit that they have booked? In 95% of the cases, we are absolutely clueless. Sometimes even when you're living in the own house, you may not necessarily know the financial situation of the parents. Because traditionally, Indians are not very good at having those conversations with our loved ones. So the children really struggled. Now, one more challenge was that because this was a situation where it was as good as a will not being made, they had to resort to court to obtain succession-related paperwork. Because today, when somebody passes away without writing a will, you can't just walk up to the bank and, claim that you're the rightful legal heir. You have to prove it. So you need paperwork to show that, yes, you are the rightful legal heir. Now, the NRI children had to be in India for a few months to figure everything out. If only a will was clearly drafted, if only the assets were properly identified, if the family had had the discussions, updated their nominations in place, they would have had those, decent discussions revolving around the assets. Thing would have turned out very, very different for this family.
Aditi, thank you for these inputs. Now, you have highlighted what can go wrong. What precautions the NRIs can take while drafting their wills, or what message they can pass on to their parents who live in India to avoid problems in future because of will being not there, or will being poorly drafted, or educating them of what needs to be rightfully done.
Right. And so honestly, it's not just the onus on the NRIs, but also the family members need to be involved to have a conversation on these important topics. See, it's very important to discuss what all assets which are there, whether it's a fixed deposit, whether it's a recurring deposit, mutual funds, bank accounts, real estate. Today in the digital age, you've got crypto-related assets. All of that is very important to have that discussion. It's also very important to make sure that nominees are properly appointed and updated in these bank accounts. Because when a nominee is appointed, asset transfer becomes really simple. Usually what happens today is that, most of us start work when probably we're in our early 20s. And that time, most of the times you have your parents you appoint as nominee. That becomes a problem because nobody bothers to update or even take a look at who my nominee is. So in most cases, what happens is that, the nominations are also invalid. Because of that, all these issues also come in. So all these factors are very important to plan and consider. I'll also share, recently we were advising an NRI family. The situation that they went through will also highlight the importance of having these conversations. So this was a resident Indian gentleman, used to stay in Gujarat. He created a will. His intention was to make sure that asset will pass on to his family in a smooth fashion. He had a wife, but they did not have any children. His brother's family stayed in the USA, and the gentleman who passed away, his NRI nephew was his closest relative. So he named him as the executor of the will. However, this uncle of the NRI did not communicate this decision to the nephew. So the NRI had no idea that he was given such an important responsibility that the uncle basically had given to him. This actually led to a challenging situation for everyone. I'll highlight what were the issues that he went through. See, of course, upon death, he was completely surprised to discover about the responsibility given. He was staying in the US, he had a job there. So naturally, he found it very difficult to oversee the matters in India for simple reasons such as time difference. You have to have some interaction with the local authorities. So it was very difficult to do this remotely. Adding to the complexity of the situation, the uncle's wife, that time one, was obviously not in the correct emotional state to handle financial matters. And also she was not very well-versed or proficient to deal in these, banking and financial related aspects. So naturally, she needed a lot of hand-holding to access the assets which were there. Now, it became very clear to this NRI executor that it's very hard to do this from abroad. So he actually planned to come to India. Now, naturally, he was working there. He had to take time off and come here to figure it out. What he also realized is the will did not even mention a backup executor. Because what happens is when you mention an executor, let's understand what is the role of the executor. Executor needs to take on certain certain administrative and operational duties. You need to make sure assets are passed on properly. Returns are to be filed. After all the asset transfer formalities are done, you need to file, like I said, returns, but also closing of PAN, Aadhaar, etc. So there's, fair bit of paperwork which is needed just to make sure everything is done properly. Now, a good will talks about an executor and a backup executor in case if the executor is not able to take this on. But because here there was no provision for a secondary executor, he could not just abandon his task because he would have to go to court to get a secondary executor appointed. So he had no option but to be and support his family that was needed. Now, being an NRI, again, there are several challenges that he faced. He was not familiar with the local language, Gujarati. In India, you need to have certain other skills to sort of navigate the complexities. Also, legal systems are difficult. Nominations were not updated here, so asset recovery process was a little longer. He finally decided to approach a local lawyer to help him with all this. But he also discovered that the asset transfer fee for the service the lawyer was charging was quite exorbitant. It was almost a double-digit percentage of the total asset value. So, unable to figure all this out, he had no choice but to just approach the lawyer to help him with all that. Now, again, these are little problems may seem on the face of it, but actually the NRI nephew went through a lot to figure all this out, disturbing his own setup over there. Had the uncle had this conversation with him, discuss that, okay, look, would you want to be an executor? Or let's figure out who is going to be an next in line. Or identify some agencies for the nephew that, look, these agencies help with asset transfer. Then the situation would have been different and they would have been better prepared to deal with such a situation.
Aditi, thank you very much. And looks very complicated, The whole exercise of making things simple at times for unintentional reasons can get complicated. Finally, before I let you go, a few tips for my NRI audience, what they can do to avoid these pitfalls.
Definitely, sir. See, the most important thing to bear in mind that your will is flexible enough to deal with many situations. Example, like we spoke about earlier, beneficiaries you must mention in the will. Also talk about the next in line of beneficiaries. At BLO, typically we add another layer, like, okay, layer number 1, let's say X is to receive it. If X is not there, Y is to receive it. If Y is not there, then Z. Just make sure this is there. Some people may, common man may review it, consider that, why have talk about such difficult things if this one is passed away, that one is passed away. But it's important from a very objectively, you think that your will should be flexible enough to cover these situations. You must have a residuary assets clause. Very, very important. I'll give you another, situation here. This was an NRI living in US. Mother was in India. Mother created a will. She wrote everything, assets should be distributed to 3 children, everything properly written. Did not mention a residuary assets clause. So there's one car which they had in India, which she did not mention. For that one car, in Bangalore, we had to obtain a family tree certificate, go to the Tehsildar, obtain that, get all the legalese in place, and then that car was transferred. So that one car, it took 1.5 months. Otherwise, everything was proper. So if the will had the residuary assets clause, which said any asset which I may have missed out or which I may acquire later or which I may inherit, those will be passed on to so-and-so. Very important. And of course, appoint an executor as well as a backup executor. If you're appointing a guardian for your minor children, appoint a guardian and a backup. So that becomes important, that your will has room, enough to deal with different situations. Now, to tackle the issue of soundness of mind that I spoke about earlier, get a doctor's certificate which will state that you are, mentally you are fit at the time of execution of the will. You can get it as close to the date on which you're signing your will. Another angle to deal with soundness of mind is you can get your will registered. So typically how you register a will is you have to go to the sub-registrar's office, typically where you go and get your leave and license or sale deed and all registered, same place. When you are registering your will, you're actually signing before the sub-registrar. That also shows indirectly that, you are of a proper frame of mind. So you went to the sub-registrar and you signed it. And also in India, there are several states, especially if your will is talking about real estate, they tend to rely more on a registered copy of a will. So get that registered. And another additional benefit of registration is that in case if your will were to get lost, you can go to the sub-registrar and apply for a copy of the will. So that gets sorted. What we would also recommend at the time of execution of the will, that is signing of the will, take a video recording of the entire process. We would recommend that the testator can read out the whole will. In case if you don't want to read out the will in front of your family, in that same shot, you read it out, you then ask your witnesses to come, those bit can be figured out. I emphasize on video recording is because we had the Delhi High Court case where the original of the will was lost, but the family had captured everything on video, regarding reading out of the will and witnesses and etc. So the Delhi High Court actually held that considered the video recording was considered as a valid will. We also recommend you to update your will from time to time. At least make sure once a year you just take a look at your will and see if it is in line with your goals and your wishes. If not, update it. It's really easy to update your will. I would also like to share that make sure your nominations are updated, because asset transfer is much quicker if your nominations are done, and just make sure that your nominations are in line with your beneficiaries that you mention in your will. A golden tip is don't put your will in the bank locker, because to access the bank locker, you need a will. Because in India, we think of a will as a very super secret document. So please don't put it there. Keep it at a home or in a safe wherever, but don't keep it in the bank locker. And lastly, please keep your loved ones informed. Tell them that you've created a will. Of course, depending on, your situation, your dynamics, but somebody should know that you have created a will. So we hope that all these tips will help you to, create a good, solid will. So you don't need to go through all the challenges that many, many NRIs have gone through.
Thank you, Aditi. That's a lot of information, a lot of care. And if people who listen to this podcast, if they follow these simple steps, take that extra precaution, then it will not create a burden for the family members who have to act on this will. Thank you very much for your kindness to spare your time and share your knowledge for the benefit of my audience. I remain in gratitude.
Thank you. Thank you so much. And once again, thank you for the opportunity that you always give. It's so good that the message reaches out to so many people so they can avoid all these really difficult situations that especially the NRI community faces. Thank you so much.
Dear viewers, hope the video that we have done today helped you to understand the precautions that you need to take and the care with which the wills have to be drafted. If it did give you a direction how you should proceed on this matter, please give me a thumbs up. If you are a person who is watching my channel for the first time, or if you are yet to subscribe for the channel, please hit the subscribe button and press the bell icon. Do not forget to share these videos with your near and dear ones, friends and relatives, and all the WhatsApp groups on which you are connected with. Thank you very much for watching this episode on NRI Money Clinic. I shall be back with you with yet another episode, with yet another expert next Tuesday. Till then, stay safe. Jai Hind.
Press the bell icon for more details and subscribe our channel.